Ladies and gentlemen, good morning. We will call this meeting to order of the Cannabis Compliance Board scheduled for today. We can get a roll call.
Great. So Member Jerry Merritt.
Present.
Member Dennis Nylander.
Here.
Member Rihanna Durrett.
Here.
Member Young is absent today, and Chairman Michael Douglas.
Here.
Great. Deputy Bala, can you please confirm that we have complied with the open meeting law requirements?
We have, sir.
Great. Well, Chair, we can get started with agenda item number 1, public comment.
If we can have whatever public comment. Good morning.
Thank you. Good morning. Stephen Cohen on behalf of THC Nevada. I'd like to make some just opening comments regarding 11.075. I want to thank the commission for and the board for what we're here today for, and that is the regulation being amended. Great strides to help for this particular issue. I would like to state for the record, though, I think there is one issue that remains to be addressed, and I thought it'd be best to do it in the public comment. When there is a failure of a test, and that goes into the 50 aggregate number, and that same lot, the way the new regulation is written, is then retested. If those retests ultimately result in a pass, I don't believe it's fair and equitable for the industry to have that still counted within the 50 aggregate number. Just like moisture doesn't count, I believe that for purposes of the amended regulation, I think that the chair or his designee should be able to administratively be able to go ahead and say, okay, I see this lot failed, but it ultimately passed. It doesn't count within the 50. That's all we're asking for today. Other than that, we thank you for the regulation as passed, and we are in full agreement with it. If I know it's difficult to ask any questions during public comment, with that, I would conclude my comments. Thank you very much.
Thank you. Anyone else?
Great. Seeing none, we'll move on to agenda item number 2. I would just say for the record, all of the public comment we've received through email will be posted online following the meeting as part of the public record. So with that, agenda item number 2, chair meeting minutes.
The minutes have been duly posted and provided to the board. If there are no additions or corrections to those minutes, we can have a motion for approval of the June 15th, 2021 minutes.
Member Jerry Merritt, I motion to approve.
Do we have a second?
Rihanna Durrett, second.
Any additional questions or corrections? Hearing none, all in favor, please say aye.
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 Motion carries. There's no abstentions and no denial. We would then move to item 3, consent agenda.
Thank you, Chair. So item 3 on the agenda concerns 2 complaints for disciplinary action pursuant to 678-8510. The Attorney General has reviewed these violations and has recommended proceeding with disciplinary action. With the recent passage of AB 49, Section 1.3 is modified to allow the CCB's executive director to serve disciplinary complaints. Under 678-510 sub 2, the board must still grant approval to proceed with disciplinary action. So therefore, today I'll be requesting the board approval to proceed with each of the 2 disciplinary actions. And if approved, I will then authorize service of the complaints. As service is now in the hands of the executive director, we are not required to immediately serve both complaints today. So once the board has approved proceeding with this action, service will proceed within a reasonable time. And I anticipate, if approved, both complaints will be filed and served within a week to 10 days. And once they are out for service, they will be posted online. So this will be the process going forward based on the statutory change. So I'll present the violations alleged and request that the board vote to authorize proceeding with disciplinary action against these two respondents. As to respondent A, the complaint will allege violations of the following regulations: NCCR regulation number 4 and NCCR regulation number 6. As to respondent B, the complaint will allege violations of NCCR regulation 4, NCCR regulation 6, and NCCR regulation 10. Chair, turn it back to you.
With that, as was stated, the board has not seen the alleged violations except for what's been presented today. And as our director has said, pursuant to the statutory amendment to change, we are just authorizing the services complaints today as to number 1 and 2 under consent item 3A. With that, we have a motion for approval of service of
Member Durrett, I move to approve complaints under the consent agenda, item A 1 and 2 against respondent A and respondent B respectively.
Thank you. Do we have a second?
Member Merritt, I second.
Been moved in second. Any discussion? Hearing none. All in favor of the motion for service of complaints, please say aye.
Aye.
Aye. No abstentions and no dissents. Motion carries.
Great, Chair. We'll move on to agenda item number 4. This is request for transfers of interest. Chief Staley is here to present the items in front of the board. Chief Staley, when you're ready.
Good morning. Can you hear okay? Good morning, Chair Douglas, Member Merritt, Member Nylander, and Member Durrett. For the record, I am David Staley, Chief of Investigations for the CCB. I'm here to present agenda item number 4, which consists of 3 transfer of interest or TOI applications. Item 4A is a TOI application for EMK Hydra Garden LLC. The applicant has requested, with board's permission, to move this item to the August agenda.
We would go ahead and move this to the August agenda. We don't need a formal motion, correct?
Please, yes, sir.
A motion?
We're okay to move that to August?
Yes.
Okay, thank you. Item number 4B are the TOI applications for SH Parent Inc. or Parent. TOI 19063 and 19063A request approval for Parent to merge with Series Acquisition Corp. Series, a special purpose acquisition company, which will be renamed Parallel Brands Inc. or Parallel. Additionally, Bakery Partners LLC and Cookies Creative Consulting and Promotions Inc. or Cookies will invest 51% in Parent's dispensary only as a joint venture. Series was formed to invest in the cannabis industry and is comprised of investment specialists with experience from Goldman Sachs and the media and fitness industries. Series went public in February of 2021 and raised approximately $2 billion. Cookies is a California-based cannabis company, and Bakery Partners is a Cookies-related entity. Bakery Partners and Cookies will invest in Series dispensary only after the Parent Series transaction has occurred. CCB staff will submit various licensing and management contracts between Cookies and the dispensary on a later item on this agenda. Due to the nature of the parallel transaction, CCB staff suggests that if approved, the approval be conditioned to require that Parallel submit an updated ownership after completion of the Parent Series transaction. In addition, Parallel has requested waivers pursuant to NCCR 5.112 and 5.125 of the requirements of NCCR 5.110 regarding a review of all owners. Parallel has adequately addressed the items required by NCCR 5.112 and 5.125 to allow the board to approve such waivers. Staff suggests that if approved, the board limit Parallel's 5.112 and 5.125 waivers to expire on such agenda date as Parallel's next TOI application is heard. Staff identified no areas of concern with this application. I am available for any questions, and my understanding is that Maggie McCletchie and various executives are present today to make a brief presentation to the board and address any questions you may have as well. With that, Chair Douglas, I'll turn the item back to you.
Before we ask the licensee to come forward, if we can see if any of the board members have questions, staff reference this item.
Good morning, Chairman Douglas, Director Klimas, and board members. My name is Maggie McCletchy, and I'm here today on behalf of DH Flamingo, DH Aldebaran, and SH Parent Inc. Also here with me via Zoom is James Whitcomb from Parallel. Mark Nye is here with me in person, who's the director of, he's the Vice President of Operational Compliance for Parallel. Also via Zoom, I have Ross Berger, who's Corporate Counsel for Parallel. I also via Zoom have Anita Sabine, who's an outside counsel for Cirrus. Joe Crothers, who is Chairman, Chief Executive Officer, and Director of Cirrus. Jordan Cohen, who's the President and a board member of Cirrus. Also with me in person today is Brandon Johnson, who is owner and Chief Executive Officer of Cookies Retail and would be the manager of the joint venture if approved. Ryan Johnson is the owner and head of compliance and is also here with me today. Upon closing, he would also be a manager of the joint venture. I also have Jessica Feingold here, who is an associate general counsel for Cookies. Also via Zoom, I have Parker Burling, the president of Cookies Creative Consulting and Promotions, and Michael Moulton, who's outside counsel for Cookies Creative Consulting and Productions. DH Flamingo and DH Aldebaran collectively hold medical and recreational dispensary production, cultivation licenses, as well as a distributorship. The entities are currently ultimately owned by SH Parent Inc., which does business as Parallel. Parallel is one of the largest privately held multi-state cannabis operators in the United States. It operates compliant cannabis businesses in other states, highly regulated states like Massachusetts and Florida. Parallel has made meaningful commitments to social equity and diversity in the cannabis industry. For example, Parallel's increasingly diverse workforce is comprised of 38% minority and 42% female identifying employees. Today, I'm here before you to seek approval for two separate transfer applications. I thank Mr. Staley and Rachel Branner and other staff for all their work on these transfers. I did want to clarify one thing that Mr. Staley said, and that's that these are two distinct applications, each of which can be approved independently. One is to contribute the dispensary license to the joint venture to be jointly owned with Cookies, and the second is for the go public transaction. Obviously, I'm here today to ask the board to approve both transfers, but they can each be approved independently. DH Flamingo, the current license holder, ultimately owned by Parallel, will still be upon approval, would still be the 49% owner of the joint venture. But first, I'll give a little bit of detail about the Cirrus transaction. Parallel is going to become subject to regulatory approval here and in other states. It'll become a public company, and this will be effectuated through a business combination agreement with the entity Cirrus that Mr. Staley mentioned. Ultimately, the stockholders of the existing SH Parent, the Parallel company, will also become stockholders of the public entity. There's going to be continuity. Through the merger, Parallel will both be able to grow and continue its dedication to compliant operations in the markets it does business in, including Nevada. Key leaders from Parallel will continue to serve as executives and board members at the merged publicly traded company. There will also be outside directors and board representation by Cirrus. Parallel will also continue its dedication to diversity, importantly, including on its post-go public board. The board and executives of the merged public entity will collectively draw on experience in highly regulated markets across the country to ensure continued compliant operations, including in Nevada, and to steer the growth of the company. Before I move on to Cookies, did any board members, I wanted to offer myself up for anybody who's here with me or here via Zoom for any questions that you may have about the Cirrus go public transaction.
Why don't you go ahead and finish your presentation? See if questions.
Thank you, Chair Douglas. With regard to the cookies transaction, as I mentioned at the beginning, subject to regulatory approval, DH Flamingo Inc. proposes to become part of a new limited liability company with Bakery LV LLC. As Mr. Staley mentioned, the new entity, the joint venture, will be named CRP Las Vegas LLC, and it will hold the dispensary licenses. However, the current license holder, and parallel through the current license holder, DH Flamingo, will continue to hold 49% of the interest in the licenses and will continue to be a partner with Cookies. Through Bakery LV Bakery, Cookies Retail LLC, and Cookies Creative Consulting and Productions and other Cookies entities will ultimately own 51% of the membership interests of the joint venture. I have Brandon Johnson from the Cookies businesses here with me today. Mr. Staley asked that he be available to make a brief presentation about their plan for business post approval.
Please, thank you.
Good morning. Thank you very much for having us here. Can't tell you how excited I am to actually be in one of these in person. It's been a while. We're very excited to be coming to Nevada, expanding from our home base in California and continuing our expansion nationwide. I am Brandon Johnson. I am the manager of the newly formed joint venture, CRP Las Vegas, and we'll oversee all management decisions and operations here locally. First, I wanted to start with, we're a compliance-driven company first and foremost. We have a pretty extensive experience, including former C-suite executives from Fortune 100 retailers, lots of multi-unit retail experience, compliance folks from the SEC, a team of compliance former regulators to make sure that we're adhering and dotting every I and crossing every T. Secondarily, I think that we are a social impact and community company culture that we've instilled across the business. We really focus on being good neighbors. We hire local. We have an extensive track record of social equity. We opened the first social equity dispensary in the country. We partnered on the first Black-owned dispensary in the country. And we try to bring and instill that culture across our supply chain, brands that we put on our shelves, that we display prominently in order to promote those sorts of ideals here in Nevada as well. And so with that, I'll open it up to any questions you may have, or we can continue on with the presentation.
Yeah, well, there are a lot of moving parts and pieces, very complex transaction. Having said that, though, we appreciate the cooperation of our licensing agents in reviewing and being vetted. With that, members of the board, do you have questions or concerns?
I have a question. Which C-suite level operator members of your team will be located in Nevada?
Most of our corporate team is based in Southern California, where our home office is. We will have director and vice president level people here in Nevada. As we continue to expand in the market, that will grow, but our home base is in Southern California. Fortunately, it's a pretty short trip over from there. So we do operate in a lot of different markets nationwide and actually worldwide. So we do have operations in 14 states and 5 countries. So as much as Nevada is a whole different state, being 3 hours away versus halfway around the world is quite convenient.
Other board members?
Mr. Chairman, this is Member Nylander. I have a quick question.
Please.
Yes, so good morning, Mr. Johnson, and welcome. I'm glad to hear that the company has been and is focused on compliance, and it appears that the department has devoted quite a few resources to that. So that's welcome from our side. But maybe if you could just tell us a little bit about how you got here and why you decided to try to do business in Nevada. What about this deal was attractive to you and bringing you into a new jurisdiction?
Sure. Nevada is a market that we've identified years ago as a very logical expansion opportunity. Again, we're a California founded company and we've struggled to find the right opportunity, the right partnership, and the right timing to get into the state of Nevada. We're very excited to partner with the team from Parallel, who bring a lot of kind of sophisticated banking experience and have like-minded approaches to compliance that we do. For us, if you think about Nevada as a tourist destination that is like no other, we have great data analytics on our stores nationwide, and we know that our stores are kind of a tourist attraction. people will fly in, and we have that data available. And so Nevada was probably always our number one priority. We just haven't been able to get into this market successfully. We're known for our genetics, which have been in state dating back pre-medical days. So there's a very logical extension to be moving into a state where we're kind of already had a presence with our products are on shelves in various stores already in the state. So for us to launch a branded retail flagship experience here in the state, it really made the most sense of just about anything we're doing in the country. So we're very, very excited to be here. This will be our largest and biggest flagship experiential retail destination. And we think that it'll find a great home here on Flamingo Avenue.
Yeah, and just wanted to ask you, how was your experience going through the investigative process in Nevada compared to other jurisdictions that you're in?
Very thorough. And I congratulate you for that, because a lot of states don't have the regulatory bandwidth in order to do that. Hopefully you guys were satisfied and vetted all of our financials, but I congratulate you guys, because this is an industry that requires strict compliance, and you guys have done a fantastic job of leaving no stone unturned. And I would encourage other states to do the same thing, because it only is beneficial to all the real players who want to do this the right way. So I appreciate staff and the entire CCB and the entire group for working with us so diligently and pushing us through quickly. I know it's been kind of a challenging year for a lot of people, and so being able to do that under these circumstances, we're greatly appreciative.
Yeah, and I think this is the first time we've seen a SPAC transaction, which I think is a very good thing. I'm familiar with it in other industries, and it's a great vehicle to do a combination and to go public in that way. But as I understand it, you have only 2 years. Do you have 2 years to finish the transaction under the SPAC rules?
So I'll defer any questions related to the SPAC with series and parallel to Maggie, who was already jumping up to help me. Before I go, do you want to answer that, or do you have any more questions for me? I guess you take it from there.
And I do have, I'm a Nevada regulatory attorney. I'm not a securities counsel, and I do have folks on the phone. But yes, this is a SPAC, which is for the folks in the room who may not be as familiar as Board Member Nylander, which is it's a entity that was specially formed to raise money and then go public. It will become the ultimate parent company of Parallel. The entity is on good track for obtaining regulatory approval in other jurisdictions as well. It obtained regulatory approval in Massachusetts, and it will be obtaining, I believe, shortly, regulatory approval from the state of Massachusetts. I believe that Ross Berger, who is a commercial attorney in-house at Parallel, is available by Zoom, and he may be able to answer some of your more nuanced questions. Board Member Nylander?
No, that satisfies my question. Thank you for that. No, it's just, it's kind of a cutting edge, way to go public right now. And it's just good to see the industry is using it, because I think it's going to be helpful for them. And then it'll be helpful for us.
Thank you.
With that having been said, anything else from our board? Then Mr. Staley, after you've been patted on the back for outstanding work and your team's work on this one, we'll put you to work. You noted that the company must provide an updated list of all owners, officers, and board members, including ownership percentages of Parallel Brands, Inc. once the SIRS merger is closed and the final valuation has occurred. As to the existing TOIs that are before us, being 19063 and 19063A, are there any other conditions or that should be put in the motion if we have a motion for approval?
Thank you, Chair Douglas, and actually I want to recognize investigator Rachel Branner for her work. I just proofed the report. She did all the hard work. So in regards to TOIs, we have 2 of them, and as Ms. McCletchie mentioned, they can be approved separately, or if the board wants to approve them in together, They are TOI 19063 and 19063A. There are two conditions suggested for these items. One is that they submit a true and correct ownership percentage, fully diluted, to the board after completion of the parallel and series combination. The second is our standard waiver pursuant to, our standard condition pursuant to waivers of NCCR 5.112 and 5.125.
All right, thank you. In light of that, do we have a motion?
Rihanna Drett, I move to approve the transfers under agenda item 4B, TOI applications 19063 and 19063A, subject to the condition that the company provide a list of all owners, officers, and board members, including ownership percentages of parallel brands once the Ceres merger has closed and final valuation has occurred, and subject to the condition that waivers under 5.112 and 5.125 of the NCCR will expire upon the submission of a additional transfer application. Correct? Okay.
And do we have a second?
Member Merritt, I will second.
Been moved in second. Any additional questions or concerns? Hearing none. All in favor of approving as so stated in the motion, please say aye.
Aye.
Aye. We have no abstentions and no dissents. Motion carries. Ms. McCletchie,
Thank you very much.
To the licensee, thank you and good luck. We welcome you to Nevada. That will move us to the C item.
Chair Douglas, members of the board, for the record, I'm David Staley, Chief of Investigations for the CCB. Item number 4C are the TOI applications for Vegas Valley Growers North LLC or Vegas Valley. TOI number 19044 was filed during May of 2019, but the transaction could not be completed, and the company has requested that the proposed TOI be withdrawn. So you'll have two TOIs before you on this item. 19044 is simply a request to withdraw. You may want to handle these as two distinct votes. TOI number 2005 was filed by Vegas Valley requesting that existing shareholders John Berg and Gobinder Chopra transfer their shares to the two remaining owners, Mitchell and Marla Wilson. Subsequently, TOI number 20005 also requests that the Wilsons sell all of their interests in Vegas Valley to Mariana Arakelin and her company, MA Royal LLC. Staff has identified no areas of concern with this application. I am available for questions, and my understanding is that Maggie McCletchie and Moses Shakirian are available to make a brief presentation to the board to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. Ms. McCletchie.
Good morning, Maggie McCletchie for the record on behalf of Vegas Valley Growers North LLC and Mitch and Marla Wilson. Mr. Staley explained these transfers very well, and I don't actually have any further clarification on these transfers. I do have with me, I do think that Moses on behalf of the buyer is here via Zoom, but I actually have in person with me, and if she could come up, I have Hasmik Jorgensen on behalf of MA Royal, the buyer, to explain a little bit at Mr. Staley's request about their plans for their business operations once the transfer is completed.
Thank you.
Thank you very much, Ms. McClatchy. My name is Hasmik Jorgensen. If transfer approved, I will be the Chief Executive Officer for MA Royal. Ladies and gentlemen, thank you very much for this opportunity to be here. I would like to thank Cannabis Compliance Board for their hard work with us as we try to get this transfer done and be placed on this agenda. I applaud the professionalism and the prompt responsiveness of Cannabis Compliance Board. This is an exciting time for two women who came together in a divine intervention, I would say, to make a difference in each other's life. Ms. Arakelin and I are best friends. We refer to each other sometimes as sisters. We both come from extremely humble beginnings. We both remember not having much as children. But as we met, we started making each other better. We came to each other's life and became a backbone to one another in all aspects of life. We simply make each other to strive for the best and not settle for less. This is how creating a business together and the plan to be successful together was born. We enjoy helping others, and we both understand that the stronger we become, the more helpful we can be to the causes we're passionate about. Causes like domestic violence and child abuse are very personal for me and Ms. Arakelian, and we would like to continue our commitment to make a difference in the lives of women and children and hopefully be an example for them. That no situation is permanent, that nobody can take their ability to dream, set goals, and go for them as hard as they can. That will be the passion that will drive this business. We're extremely fortunate to have met Mitch and Marla Wilson and have discovered Vegas Valley Growers North LLC. This is a family who has managed to create a wonderful legacy in this industry by their professionalism, ethics, and ability to run compliant operations. We would proudly like to continue that. We're fortunate to have learned from them throughout this purchase. We'll maintain all the brands and products by VVGN as we launch our own wonderful brand with its own unique product lines that we strongly believe in and look forward to introducing to CCB and hopefully be approved for. We're also working on a unique wholesale model of providing raw materials to other production companies that would make it easier for them to be consistent on their formulations and ability to continuously pass their tests. We're working with the Wilson family in constructing and completing a designated building for the purposes of cultivating premium quality cannabis and executing the previously mentioned production plans. Our mission for our product is to create quality medical products for people that are actually good for them. This is particularly important to Ms. Arkellen and I because we have both lost a family member before their time to illnesses that would have been possibly preventable by the use of cannabis. We have gathered a qualified team of professionals that we believe will be able to execute those plans successfully. We understand any startup has its own unique challenges, but if me or Ms. Arkellen ever doubt how far we can go, all we have to do is look back and see how far we have come. We're certainly professionally and personally qualified to do so. A little bit of my experiences, I started in cannabis field about 2016, assisting local executive. Every time I tried to leave the cannabis field, I was pushed back into it. And I was like, might as well learn it as much as I can. I've been operations manager for 2 years for a local company. I understand operations compliance. I have spent a couple of years being in touch and closely working first with Department of Taxation, then with Cannabis Compliance Board. So we understand the regulations, we understand what it takes, and we look forward to take this challenge. And I won't lie, we're nervous, but we're also very excited, and we know we can get this done. And that concludes my presentation. If you have any questions or comments, please, I would love to hear or answer them.
Questions by our board members?
I have a question. This would be a totally awkward, weird question outside of a meeting like this. And inside of a meeting like this, I think it's appropriate. I'm curious where in general, where the funding is coming from to purchase. Is it your partner's funding that she already had, or is it a loan in general?
So my partner owns and operates a very successful billing company. She bills for 17 medical offices in the area of Los Angeles. She also owns a dental management company that oversees a couple of dental offices. So she's a successful businesswoman. She, again, like I said, comes from nothing, but has been able to take a big jump. So she will be primarily bringing in the finances.
Thanks.
Thank you.
Other board members?
No.
Mr. Chairman, just a quick question. So the Wilsons will have no involvement once the transaction is completed?
No, they won't, but I will let Ms. McClatchy to comment further.
So part of the purchase price is going to be financed through a note that the Wilsons will hold. So they will continue to be holders of the note. This was included in the documents provided with the purchase agreement. So they will continue not as owners and not as employees, but they will continue to hold the note that will be secured by the by the licenses. So they will continue to be involved in that way. Additionally, the Wilsons own the company on which the business is currently operating, and they will also be involved in the build out as Hasmeek mentioned, they will be involved in the build out of the new planned facility.
Okay, so they're basically going to be a lender though in the long term.
Correct. They will not be involved in they will no longer be involved in the operations. They have enjoyed the industry, but it is time for them to exit the industry.
Understood.
They're
Thank
happy
you.
to- Thank you.
All right, with that and pursuant to recommendation, if we would proceed with TOI 19044, and that was the withdrawal of that request. And we need a motion, so we can formally do that and approve it.
Member Merritt, I move to approve.
Do we have a second for that withdrawal motion?
This is Member Nylander. I would second.
It's been moved and seconded. Any additional discussion? Hearing none. All in favor of the withdrawal of that TOI as the 19044, please say aye.
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 Motion's been carried. No dissents, abstentions. Now we move for our main motion as to the venture going forward as to 20005. Do we have any conditions that need to be placed?
No, Chair Douglas, there are no suggested conditions on this item.
Having heard that, if we can get a motion.
With no condition, this is Member Merritt. I motion to approve.
For a motion for approval, do we have a second?
Member Durrett, I second.
In light of that, any additional discussions or questions? None. So all in favor, please say aye.
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 Motion carries. All parties saying aye. No dissents, no abstentions. Ms. McCledgy, and to the licensee, thank you very much.
Thank you very much.
Chair, that takes us to agenda item number 5. This is a consideration for approval of service agreements. Turn it back over to Chief Staley, who will handle this item.
Good morning, Chair Douglas, members of the board. For the record, I'm David Staley, Chief of Investigations for the CCB. I'm here to present agenda item number 5 and number 6, which consists of requests for approvals of various management and licensing agreements. Item number 5 is a series of March 11th, 2021 service agreements between DH Flamingo Inc. and Cookies Creative Consulting and Promotions LLC, consisting of a retail license agreement, property management agreement, inventory management agreement, and support services agreement. The agreements are part of the business combination previously approved under agenda item number 4B. Staff has reviewed the agreements and found them appropriate. CCB staff recommends that the board consider approval of the relationship between Flamingo Parallel and Cookies related entities rather than approval of the agreements themselves. Approval is recommended only for this relationship, and it should be made clear that the CCB is not approving, condoning, and or accepting any particular advertising, signage, packaging, particular use of logos or trademarks, and or anything else to be used by the licensees. I am available for any questions, and my understanding is that Maggie McCletchy and other executives are present to make a brief presentation to the board and address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. Ms. McCletchy? Are you taking all of us back to a contracts question?
I will be I'll be very brief. These are just a number of peripheral agreements that now that you've approved the transfer to the joint venture with Cookies, these will get assigned to the joint venture. These do provide for various profit sharing payments based on gross revenue, which is why in speaking with Mr. Staley, and thank you again to Mr. Staley and Ms. Branner for all their help on these transactions and as well as the transfers, we determined it was appropriate to ensure that as Mr. Staley just said, the relationship between Cookies and CRP or DH Flamingo, was approved by the board. The entities, Mr. Ryan Johnson is here, who a compliance person with cookies and will also be a manager of CRP, and he can explain some of the intricacies of the agreements. It's my understanding that today the board independently approved both the transfer to CRP and the go public transaction at parallel. So it's my understanding that that the transaction with regard to the dispensary, that transfer will be deemed complete upon letter from Mr. Staley and local approval. Accordingly, the consulting agreement, just to be clear, that was one of the documents that was before you. The consulting agreement will not be assigned to the joint venture. The other agreements, however, will. The entities, there are a number of different cookies entities that you may have seen in these documents or in the report from Ms. Branner, but they all are the same cookies ownership and cookies group of companies. So unless you have further questions, and again, I do also have Mr. Berger from Parallel and Ryan Johnson from the cookies companies, if there are further specific questions about these agreements.
Questions by our board members?
Member Drett, for the record, and I think someone from your team will probably need to answer, who will be in charge of compliance? What will be the highest ranking person in charge of compliance? It's not gonna be the COO, is it a director of compliance?
I will let Mr. Ryan Johnson answer that question, but he, along with Brandon Johnson and a designee from Parallel, there will be 3 managers of CRP. There will be 3 managers of that LLC. That LLC will hold the license. So it's my view that LLC and therefore the 3 managers will ultimately be accountable and responsible to the Cannabis Compliance Board and local authorities in Nevada for compliance matters.
Thank you, Maggie. And yes, she's correct. There are 3 managers of the new joint venture, myself, Brandon, and a Parallel member. Ultimately, all of the compliance requirements will rest with us. However, we do have a team of compliance individuals that will be supporting the store, and that includes Jessica, who's here, our Associate General Counsel, and we have other a Director of Compliance and other people who are involved in compliance with all of our stores and this one as well.
Will there be a director of compliance in Nevada, or they'll be regional?
It will be regional.
Okay, thank you.
Thank you.
Other questions? If there are no other questions, then can we have a motion for approval of this service agreement? And as was indicated, it is as to approval only of the agreement.
Mr. Chairman, this is Member Nylander. I would move for approval of the agreement as stated on the record, with the clarification that we're actually approving the relationship between these parties and not any particular advertising, but rather those would fall underneath the existing regulations to ensure that whatever advertising they do is appropriate. So we're not, the motion is to approve the relationship, but we're not approving any specific advertising.
Thank you. Do we have a second?
Member Merritt, I second.
Been moved and seconded. Any further discussion? Hearing none, all in favor, please say aye.
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 Motion carries. All members for approval. We move to our next item.
Chair Douglas, and the board, for the record again, I'm David Staley, Chief of Investigations. Item number 5 is a lease agreement between Cheyenne Medical LLC and 2975 Sammy Davis Jr. Drive LLC. The lease agreement provides for the participation by Sammy Davis Jr. Drive LLC in the revenue of Cheyenne Medical's adult use cannabis retail store. CCB staff have reviewed the agreement and found it appropriate. CCB staff recommends that the board consider approval of the relationship between Cheyenne Medical and 2975 Sammy Davis Jr. Drive LLC rather than approval of the agreements themselves. I'm available for any questions, and we're going to give Ms. McCletchie a break. My understanding is that Amanda Connor is present today via Zoom to make a brief presentation to the board, address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. Ms. Connor?
Good morning. Good morning, Chairman Douglas and members of the board. First, thank you for allowing me to appear via Zoom. I had a family vacation scheduled for almost a year and didn't want to miss out on time with my family. I am here on behalf of my client, Cheyenne Medical, and the landlord, 2975 Sammy Davis Jr. Drive, to request approval. As Chief Investigator Staley stated, this is a lease agreement that is fairly common in retail commercial space. It has a minimum base rent, and then once a certain threshold is hit, a percentage of profits will go to the landlord. The landlord's principals did come forward and obtain agent cards, and two of the principals also made themselves available and went through interviews with Chief Investigator Staley and Ms. Rachel Branner. My client kindly requests approval, and I'm happy to answer any questions the board may have.
Questions by the board?
Okay, we can't let you off that easy. I missed it. Is your client here?
I do
Or on Zoom?
have, yes, in person, although I can't see him, one of the owners of Cheyenne Medical, Mitch Britton, should be in the room available.
Oh yeah,
for
okay,
questions as
that
well.
was it. Thank you.
It appears that you're going to get off lightly for your vacation. Seems to be no
Well-
questions at this time. If we have no questions, if we can get a motion for approval of this lease agreement.
Member Merritt, I motion to approve.
We have a motion for approval. We have a second.
Member Durrett, I second.
It's been moved and seconded. All in favor, please say aye.
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 Aye. We have no abstentions, no dissents. Motion carries. Thank you.
Thank you.
Chair, we will move on then to agenda item number 7. This is consideration for approval of the amended plan of correction and supplemental information and ultimate lifting of the suspension for NLV Wellness LLC. We have Chief Cronkite here to give a little bit of a background on this issue, and then we have counsel and representative from NLV to give a short presentation on what transpired up to this point. So Chief Cronkite.
Good morning, Chair and members of the board. Kara Cronkite, Chief of Inspection and Audit for the record. On May 19th, 2021, CCB agents conducted an unannounced routine inspection at NLV Wellness LLC. Inspectors observed several deficiencies, including numerous untagged plants. Several additional CCB agents, including myself, arrived to assist with the inspection later that day. In total, over 500 plants and over 29,000 grams of usable cannabis were observed in the facility, but were not in our seed to sale tracking system metric and were not tagged as required. This posed a risk of untested and untracked cannabis leaving the facility and potentially ending up in the illicit market. The following day, an emergency board meeting was held and the board voted to summarily suspend NLV Wellness LLC. That same day, the summary suspension was delivered and the facility ceased operation. During the suspension, CCB agents were on site to observe the destruction of all untagged plants and cannabis within the facility. NLV Wellness also hired regulatory counsel to assist in its goal of continued compliance with the regulations, including properly tagging plants and using the seed to sale tracking system. On June 14th, CCB agents conducted a walkthrough at the request of NLV Wellness's counsel. At that time, any remaining deficiencies were brought to their attention. On June 18th, we received a corrective action plan from NLV Wellness requesting that we lift the suspension. On June 23rd, the suspension was conditionally lifted upon approval of the board, and NLV Wellness was permitted to resume operation after their 34-day suspension. It is my understanding that the licensee and counsel are available to address the deficiencies and answer any additional questions. With that, Chair Douglas, I will turn it back to you.
Thank you. On behalf of licensing,
Kevin Brenner, on behalf of NLE Wellness with Amanda Connor.
Good morning, Chair Nyland, Chairman Douglas, and members of the board. I am still here, not on vacation yet. I do have my associate and my client present in the court there to answer any questions. I'm happy to go over what my client has done to this date and will continue to do to maintain compliance if the board would like. Yes, okay. As Ms. Cronkite stated, my client got the summary suspension order on May 20th, and immediately after retained my office on May 21st, and we started working with them to review regulation requirements and help them bring their facility into compliance. NLV requested the staff to come out and witness, and as Ms. Cronkite stated, all untagged product and plants were destroyed as witnessed by CCB staff. They also, under the witness of CCB staff, harvested plants that were tagged, and that was done properly in accordance with the regulations. They have also taken several other steps during the time of the suspension to correct deficiencies, things like cleaning the facility, getting some plumbing repairs and general facility maintenance done, which was done under supervision of CCB staff. Training has been implemented, new agents that were approved to be in the facility during the suspension, and then agents since the suspension has been lifted that were brought on have gone under training as required by the regulations, but also to kind of in-depth onboarding training of what is required. Also, in addition, when the summary suspension was lifted, I myself, along with other members of my team, did a compliance walkthrough with Mr. Ali, who is present today, to go through their facility and discuss regulation requirements. And we're going to do that on an ongoing basis to help the facility maintain compliance. So some of the things that they've committed to do that they've already done are the training, the destruction of product, making sure their inventory is was observed by CCB. They are tagging plants as they're coming into the facility. They hired regulatory counsel. They're continuing to utilize regulatory counsel, continuing to do training. They are continuing to do facility maintenance as approved by CCB staff. And they take this very, very seriously, use this almost as like a reset button to make sure that they started over. Like I said, almost all product in their facility was destroyed as witnessed by CCB staff, and they cleaned the facility greatly, had people out there to make sure all the facility was up to the regulation requirements, and they're now willing and wanting to operate in compliance, and kindly request that the board approve their plans of correction as submitted.
Questions by board?
Member Dredd, can we hear from Mr. Ali just a couple sentences on basically reflecting what you view as necessary going forward?
I just want to say that, I don't want to make any excuses. I just want to ensure the board that moving forward, we will make sure that we're 110% fully in compliance with all rules and regulations. And again, I don't want to make any excuses for the oversight that happened, but I just want to say moving forward, as someone who identifies as a true social equity person and applicant and small business owner here in Nevada, a lot of people look up to me from my community, and I'm disappointed in the fact that, this happened. And I want to make sure moving forward that I can be a good example to those who look up to me.
Thank you. I think that's the best way to put it. No excuses, but going forward it'll be different. How often do you anticipate that you'll do like regulatory checks at your facility like, voluntarily? 'Cause that seems like it's probably a really good tool.
Well, with the regulatory council, I'm leaving that up to them as to when they, whatever they want to do as far as when they want to come doing compliance walkthroughs. I'm in the process of hiring a full-time compliance person that's going to be literally every day. That's going to be their job, is walking through the facility and making sure that everything is done, within compliance and within what they've been trained to do. Also going to have our full-time compliance person in close contact with regulatory council to make sure that they're up to date on all the standards and regulations.
Thanks.
Other questions or comments? Hearing none. From my standpoint, looking at this item, I applaud your plan that you put forth going forward. I would say for the record, we are still looking at this, making a decision whether or not disciplinary action is appropriate in light of the violations that occur. We do understand that you had a tremendous economic loss because the plant's being destroyed and so on, but it doesn't really deal with the fact that this was kind of an outrageous event that occurred on the facility. And we've noted that. But what is before us today is to approve the amended plan of correction and supplemental information lifting suspension formally. So a motion for that, unless there's any comment.
I have one more comment, Chairman. I've said this before. It is so shocking to me that there's some facilities without a person in charge of compliance, because you have on one end of the spectrum, you have ones that have, general counsel, and I know some of them are smaller and don't have as much funding. So I just think those facilities out there, doesn't even pertain to you now. The facilities out there that don't have somebody in charge of compliance and aren't taking compliance seriously, this is going to catch up to you eventually. Thanks.
All right. Can we have a motion for approval of the plan of correction?
I move to approve.
We have a motion for approval. Do we have a second?
Member Merritt, second.
Any additional discussion? All in favor?
Aye.
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 Matters.
Thank you.
Approved.
Thank you.
Thank you.
Correction. And we wish you good luck.
Thank you.
We really would not like to see.
Okay, Chair, we'll move on to agenda item number 8. This is the consideration of the proposed settlement agreement to resolve disciplinary action, Cannabis Compliance Board versus Red Earth LLC. Now have our counsel, Senior Deputy Attorney General Chris Rath, here to present this item. Deputy Rath.
Thank you, Executive Director Klimas, Chair, members of the board. Good morning. L. Christopher Rath, Senior Deputy Attorney General. We have one settlement agreement up for approval at this meeting under agenda item 8. As usual, I'll provide you with a brief summary and the Attorney General's recommendation for approval. You may then ask me any questions you wish, and counsel for the respondent, Mr. Adam Fulton, is also here and present to respond to any questions you may have, and then you may decide on the action to be taken on this matter. We're here concerning the case of CCB versus Red Earth LLC, CCB case number 2021-41. This case does not involve a complaint, as rather an agreement was reached to resolve the matter without the filing and service of a formal complaint. This case involves an unauthorized transfer of interest. More specifically, as set forth in the settlement agreement, in April 2021, CCB staff found out that MJ Holdings Incorporated had purchased ownership of the license Red Earth in December 2017. The transfer had never been approved by the Department of Taxation or CCB. CCB staff contacted the licensee for further information on this issue and received a response from their counsel in May. Counsel acknowledged the transfer had been made without the required approval and agreed that the licensee would unwind the transfer. CCB staff then involved the Attorney General's office to negotiate with respondent through its counsel to see if all these matters could be wrapped up and resolved with a settlement agreement. We were able to reach a mutually acceptable agreement subject to CCB approval as set forth in the settlement agreement. As indicated in the settlement agreement, respondent waived its rights to the filing and service of a disciplinary complaint and admitted to the imposition of one Category 2 violation for failing to notify the Department of Taxation of a change in ownership interest. The respondent agreed to pay a $10,000 civil penalty. In addition, the respondent agreed to unwind the unauthorized transfer via termination agreement of the purchase as a corrective action. That's set forth in paragraph 17 of the settlement agreement. As part of the settlement agreement, CCB staff will review the unwinding documents and must approve them. Once that has been done and full payment has been made of the civil penalty, this matter can then be closed and there'll be no need for submission of TOI requests for the unwinding. CCB staff agrees that the submitted violation, the civil penalty, and the unwinding of the purchase appropriately addresses their areas of concern, and the licensee and their counsel have been fully advised about, and they understand the requirements and procedures for obtaining approval for transfers of interest moving forward. Accordingly, the Attorney General recommends and requests that CCB approve the settlement agreement. I'm available for any questions, as is Mr. Adam Fulton for the respondents.
Mr. Rath, it's my understanding from the report that you're referring to it as an unwinding. There was an agreement, but in actuality, no business was done.
Yes, that's correct. And Mr. Fulton can clarify that for you further if needed.
Chairman, may I make a disclosure? I just realized I should have made it at the beginning, but it's fairly inconsequential, so I didn't even remember it. I just want to disclose that Mr. Fulton represents my mom on a civil litigation matter. I don't feel anything about that would impact my independent judgment. So I'm just going to disclose and still vote on the matter.
Thank you. Go ahead, please.
Thank you, Chairman and members. That is correct. There was no business conducted by the MJ Holdings. That was never done. The transaction did occur. We acknowledge that. The TOI was never submitted, but no action was ever taken. The company, the licenses pretty much remained dormant, and no company operations occurred. There were no plants in the facility. No growing occurred. And as a result of what happened, we're unwinding that deal.
All right. And your client has signed off, has agreed to this agreement.
Correct. And Paris Valores is here as well, who's the current owner of Red Earth, and has approved this as well. Correct.
Thank you. Questions by board members? If we have no questions, can we get a motion for approval of the settlement agreement?
Member Merritt, I motion to approve on the settlement agreement.
Member Durrett, I second.
Been moved and seconded. Any additional questions? Hearing none, all in favor of the acceptance of the settlement agreement, resolving discipline as to Red Earth LLC. Case number 2021-4, please say aye.
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 Motion's been carried. It's been approved. No dissents. Thank you very much.
Thank you. We appreciate it.
Okay, Chair, moving on then to agenda item number 9. This is consideration of approval for deadline extension for RG Highland Enterprises, Inc. And just for the record and for the board, this extension is what the board approved a number of months ago, setting a deadline of February 5th, 2022 for licensees not yet operational to become operational in an effort to kind of clear the decks and clean out some of the outstanding licenses that have been out there for a number of years. And so this is the first request of this nature for an extension, which is allowed under the regulations. Chief Steve Gilbert is here to present on this item, and I believe council and the licensee is here as well. So Chief Gilbert, when you're ready.
Thank you. Good morning, Chair, members of the board. Steve Gilbert for the record. I am here today to present agenda item number 9, which consists of a petition submitted by RG Highland Enterprises, RG Highland, to extend the February 5th, 2022 deadline to receive a final inspection by the CCB. RG Highland was issued a provisional medical cultivation license on November 3rd, 2014, and a conditional adult use license on September 21st, 2018. They were issued a final medical license on October 1st of 2015 to begin operations, but later had to cease operations due to the Nevada Department of Transportation's Project Neon Freeway expansion, which forced them to vacate the location in March of 2017. On October 12th of 2020, the Cannabis Compliance Board issued a notice to RG Highland that their cultivation facility must be inspected and approved for final inspection by the CCB and complete appropriate local governmental requirements no later than February 5th of 2022, or the license will expire. On June 25th, 2021, RG Highland, through their legal counsel, submitted a letter to the CCB requesting the extension of the February 5th, 2022 deadline until August 30th of 2022. In the letter, they outlined the facts surrounding why they vacated their original location, their efforts to secure a new location, and the delays they are currently experiencing. CCB staff responded on July 9th of 2021, requesting a more detailed timeline of the progress that RG Highland had made from October 12th, 2020 to present on perfecting its conditional license. On July 10th of 2021, RG Highland submitted a detailed timeline of events showing steps taken and investment in their new location they have made from August 2020 to July 12th of 2021. It appears appropriate for the board to consider extending the deadline for RG Highland, and staff have no additional concerns with the application. I'm available for any questions, and my understanding is that Amy Sugden and Richard Gnocchi are present today to give a brief presentation and address any questions you may have as well. With that, Chair Douglas, I'll turn this item back over to you.
Thank you.
Good morning. Good morning, Chairman Douglas and board members. I appreciate Mr. Gilbert's succinct presentation of the facts. I've been fortunate enough to actually have represented RG Highland for at least 6 years now. I saw that entity, and my client, Mr. Denoki, is here as well. He's in orange, so you can find him easily in the front row. And we have slogged through this unique situation in which, it's fitting that this is the first application for an extension before the board, because RG Highlands was actually the first cultivation operational in the city. Unfortunately, he was displaced by Project Neon, as Mr. Gilbert explained. And so I submit to you, this isn't one of those situations where the paper has been sitting for years. He was actually operational. A series of unfortunate events, which we detailed, and I won't go over again with you guys, but I know the board has reviewed those materials from SUP denials to petitioning that, to working through it, to then getting COVID coming at him. He's finally under construction. This is really a precautionary measure. We anticipate completion right around February of 2022. Unfortunately, the state of affairs, who knows what's going to happen between now and then. We're optimistic that construction will be completed in time to get the certificate of compliance approved. It's just super close. So we respectfully ask for a 6-month extension to August 5th of 2022 to ensure that everything he's gone through finally can be respectfully, corrected and he can operate again. If I have any questions, we're here for those.
Thank you for the document outlining the timeline in terms of the condemnation project, the delay in getting funding, so you get another building, the issues at City Hall. The only question I had is whether or not there was any relocation assistance, or what kind was provided on top of the condemnation, because they should have relocation assistance.
Kurt, I understand, Chairman Douglas, you've probably had a few of these cases, before the Supreme Court. Certainly a very interesting area of law. And yes, there has been some relocation efforts as we've gone through this. NDOT has been very helpful in helping to review submissions and approve some additional resources to help with the build out. That process, and I believe Mr. Jeff can confirm, has all of that been met as far as, is there any additional? Very little. Okay, so there's very little outstanding yet to still be completed by the state as it relates to whenever a property is displaced and there's a tenant, there are certain benefits that we get under the Uniform Relocation Act to ensure that that tenant can be relocated. So I believe that's what the chairman was asking about. Hopefully I answered that okay.
Sure. Questions by board members?
Member Durrett, just a comment that it is great to see how proactive you guys were to come before the board and request an extension this early out, and a great explanation of what is going on. Thank you.
Oh, thank you. And we appreciate that opportunity.
With that, a motion for the extension of time as requested. It was a 6-month period, correct?
Yes.
If we can have a motion.
Rihanna Durrett, I move to approve for a 6-month extension.
This is Member Nylander, I'd second.
Been moved and seconded. Any additional questions? Hearing none, all in favor, please say aye.
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 Thank you. Motion carries, and good luck and best wishes.
Thank you very much.
Okay, Chair, with that, we will move on to agenda item number 10. This is the consideration of proposed amendments and or additions to the Nevada Cannabis Compliance Board regulations. We've got a large number here in front of the board today. These had been informally workshopped for a period of time, and then we hosted a formal workshop as well on these. And so the board has seen these before. Deputy Director Michael Miles will present this item, who's behind the TV a little bit, but I will turn this over to Deputy Miles to handle this agenda item.
Good morning, Chairman Douglas, Member Nylander, Member Durrett, and Member Merritt. For the record, my name is Michael Miles, Deputy Director of the Cannabis Compliance Board. I'm going to go through the proposed changes to the regulations, several of which are housekeeping in nature and several of which were through the petition process. If there are questions by the board members, the CCB staff is here to respond to those questions. Reg 1, there's one proposed change to Regulation 1, which is in the definition section. Due to some potential confusion, NCCR 1.135 is being updated to further clarify what packaging means. Staff is preparing for the next workshop, which will be on packaging and labeling. Does any member of the board have any questions as to NCCR 1.135?
None.
No.
Okay, now we move on to Regulation 3. As the Cannabis Advisory Commission was just recently appointed and had their first meeting earlier this month, there are two proposed changes to NCCR 3.020 and 3.025, and in addition, NCCR 3.030 to the regulations governing commission meetings. These changes govern how the commission handles its agenda and appoints subcommittees. Does any member of the board have any questions as to NCCR 3.020, 25, or 30? Great. Okay, now we'll move on to Regulation 4, which governs discipline and disciplinary proceedings. The changes to Reg 4 add violations and penalties to various category violations. NCCR 4.035 adds that transporting or storing of cannabis from an unlicensed source, as well as diversion of cannabis to a Category 1 violation. Furthermore, it adds that even one violation of diversion of cannabis requires revocation of license, certificate, and or cannabis establishment agent registration cards. We received a comment on one section of this change at the workshop. So staff included, well, excuse me, I skipped by. We received a comment on one section of this change at the workshop, so staff included or consumer in 4.035, subsection 1A15. Also, there was a concern from a member Nylander regarding a presumption, and we made that change there as well. NCCR 4.040 adds any violation of NCCR 11.070 to a Category 2 violation. NCCR 11.070 covers the duties of a testing facility regarding the samples to be tested.
NCCR 4.050 adds a prohibition of using unauthorized ingredients to a Category 3 violation. NCCR 4.055 adds a violation of a testing facility's business practices regarding failed lab testing to a Category 4 violation. Due to confusion, NCCR 4.135 amends the procedures on arguing disciplinary recommendations in front of the board. Does any member of the board have any questions as to the aforementioned NCCR changes and additions? Great. Okay, now we'll move on to Regulation 5. The change to Regulation 5 is in NCCR 5.140, and it is solely to decrease the fee to obtain a replacement agent card. Does any member have any questions as to NCCR 5.140?
That reduction's from $150 to $75, correct?
Correct. Okay, now we move on to Regulation 6, which covers the production and distribution of cannabis. NCCR 6.035 and 6.040 are holdovers from the Marijuana Enforcement Division's regulations. NCR 6.035 updates the confidentiality provisions from Nevada Division of Public and Behavioral Health to the CCB. NCCR 6.040 is being deleted in its entirety as the DPPH handles the tracking and evaluation of attending provider of healthcare. NCCR 6.065 is being updated due to recent confusion on which establishment had the right to transfer to a new location. This new section requires proof that a licensee has the right to operate at the new location. NCCR 6.080 allows for cultivation facilities to combine different lots of kief as long as each lot individually passed testing prior to combining. Previously, the regs stated that lots of collected resin could not be combined. NCCR 6.120 simply clarifies that all advertising by the cannabis establishment contained visible and legible required warnings. Does any member of the board have any questions as to the aforementioned NCCR changes and additions? Okay, now we'll move on to Regulation 11, which covers cannabis independent testing laboratories. NCCR 11.010 states that if the required scientific director is no longer employed by a laboratory, a qualified interim director can be appointed for no more than 90 days. NCCR 11.015 requires the implementation of business practices structured to safeguard impartiality. At a minimum, a lab must not offer a different fee structure for undesirable test results, and that compensation is not permitted for the reason of failing a lab test. NCCR 11.025 makes it clear that board agents can inspect all records maintained by a cannabis independent testing laboratory. NCCR 11.040 requires the lab to maintain any documented investigation findings and any resultant corrective actions for a minimum of 5 years instead of 2 years. NCCR 11.050 clarifies the requirement that all samples must be homogenized by the lab before testing. NCCR 11.070 also clarifies an existing requirement that cannabis cultivation facilities must present the entire lot to the lab representative when collecting the sample. Again, this is not a new requirement, just a clarification. In NCCR 11.075, an allowance has been made for cannabis cultivation and production facilities to request permission from the board for an additional 50 retests per calendar year. If the board approves this, each lot must receive 2 passing tests in order to be considered a pass. Cultivation and production facilities may also request permission to remediate failed product rather than just sending it to extraction. As a reminder, THC Nevada LLC filed a petition with the board to amend NCCR 11.075 regarding the increase in the 50 retest limitation. In response to their comments at the workshop, staff amended the proposed changes to include that retests are only required for the category in which the product failed, and it resolved the issue on recording certificates after multiple tests. Does any member of the board have any questions as to the aforementioned NCCR changes and additions?
As to this category, this area, as to 11, 11.05, we received some concerns, reference that area at a late date. Any comments as to those, that request?
Not really any comments to that request, Chairman. We just believe that structuring payments to allow reduction of price for failed tests probably gives the wrong look of the industry. Again, I have Chief Cronkite here to explain a little further what we mean by this.
Good morning, Chair and members of the board. Chief Cronkite for the record. Yeah, it's our belief that providing incentive to the labs to pass the test and encourages them to implement practices that may not be the best for public health purposes. So we think that, you know, any opportunity to discourage any facility from pressuring the laboratories to reduce payments for fails or encourage passing results so that they can receive their payments should be discouraged.
And to be honest, I know this is an oversimplification, but I say compared this to the old policy that Domino drivers had 30 minutes or less to deliver a pizza or it's free. Well, if those continued deliveries ended up being free pizzas, what happens to those delivery drivers? So again, it creates an incentive to pass rather than to fail tests.
I understand the intention of that. I'm a little concerned in light of the memorandum we received that puts forth some legal principles that I would like to spend a little time taking a look at. But thank you for the response as to that. The other is as to our last one on that, the retesting and whether or not, if upon retest, we have a favorable retest, if we should count that first failure against the party.
Actually, I'll definitely let Chief Cronkite answer this question.
So to Chief Cronkite for the record, today was the first time we're hearing this. We did not receive any responses from THC Nevada prior. So that's something that we could definitely consider looking into, is not counting the passing retest results. Additionally, to compensate for this limit of 50, we have implemented the allowance to remediate after fail. So that would not count toward the retesting request. That would just be a request to remediate after fail. And additionally, what's the other one we did? We addressed their concern to only test the specific category so they wouldn't hit so many.
Understanding the category, the question is more specific in light of what we have today. If they fail the first time, on retest they passed, would it be considered a remediation so it's not counted as a failed item? Or would we have to make a change to have it done that way?
Kara Cronkite for the record, if they do remediate and then if they request to remediate after fail, that would not count toward their 50 retest limit. A retest would only be challenging the original lab results. That's where that 50 would come.
Anyone else have questions?
Member Durrett, I had pretty much the same questions. So I would like to propose that if we do move forward on adopting the current changes in 11.05, that we still bring back that one section at the next meeting for consideration of whether or not we are also going to make the change as to whether a successful retest counts towards the retest limit. So we could have a little more discussion on it.
I'm more inclined to want to hold both 11.015 and 11.005 70. That's just me until we have more precise language.
11.075.
Excuse me, 75, until we have more precise language. That's just my position. I don't know if other board members want to weigh in.
With your indulgence, Mr. Chairman, I just like to state for the record that for purposes, Mr. Kulitz is here, the general manager, and he just informed me that unfortunately THC, and I don't know about other similarly situated licensees, are in the same boat, but we're out of the 50. So, consideration to approve as is, and then, we would respectfully request this matter come back on that issue, or I can propose language right now, very simple language. In subsection 7, Nick, why don't you come up here?
I'd like to hear your proposed language. I'm more inclined, in light of what you're saying, is to pass that and as is and bring it back. So we have a chance to really vet whatever that language might be.
Yeah, Chair, we could definitely pass 11.075. We're going to have a new workshop soon for packaging and labeling. We could add that to it as after we discuss it. Maybe we can add some kind of language into 11.075 that discusses that, and then we can talk about it at the workshop.
Oh, yeah. So rather than hold it, but if you have, in light of that, if you would submit that language in writing.
Thank you, Mr. Chair. I'll submit to all, including council and the investigation, Mr. Miles. Thank you very much.
Thank you.
Any other questions to section to NCCR Reg 11?
We can, unless a board member has anything else as to 11, if we can move to 12 then.
Okay, now we'll move on to Reg 12, which covers packaging and labeling of cannabis products. Due to some confusion, NCCR 12.015 has been amended to state that an edible cannabis product that can't be clearly demarked, each serving of cannabis with a dose of THC must not contain more than 10 milligrams of THC per unit, or the single serving must be individually wrapped. It is no longer enough to just make the product easily separable. Also, NCCR 12.045 was amended to make it clear that this regulation was only applicable to edible cannabis products. Does any member of the board have any questions as to NCCR 12.015 or 0? Great. Now we'll move on to Reg 13, which covers cannabis distributors. As requested by a petition, NCCR 13.020 was amended to allow storage at a cannabis distributor for purposes of sorting cannabis and cannabis products for no more than 72 hours. NCCR 13.025 requires that 2 drivers be utilized for the transportation of cannabis and cannabis products. Again, a petition was filed requesting the removal of that rule. Staff amended the proposed changes after hearing Blackbird's comments at the workshop. Staff increased the value of the product and the distance traveled between establishments before 2 drivers are required. Does any member of the board have any questions as to NCCR 13.020 or 25? Great. Now we'll turn it back to Director Cannabis to continue with the agenda.
So, Chair, I think this will go back to you and the board to vote on adopting these regulations, assuming your intention is to take them all with one vote, unless there's any other changes, but I'll turn that back over to you.
In this case, I will make a motion. I don't know if I'll get a second, but I'll make a motion anyway to take this in one vote, asking that we hold as to 11.015, bring that back in 1 month consideration, understanding that as to 11.075 will pass as is, and that will be considered coming up at another workshop, but for approval of all others, and as I said, holding only 11.015 and moving that till next month for consideration of the authorities that were presented to us at the late date.
Member Durrett, I second.
Any discussion? All in favor of approving the changes and regulations as presented? Uh, Please say aye.
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 Motion's been carried by all parties, no dissents, no nays. With that, the matter is approved.
Thank you, Chair. Moving on to agenda item number 11. This is petitions filed pursuant to NRS 678A 460. This particular petition from Crooked Wine, DBA Blackbird, has been on the board's agenda for a number of meetings. Believe we're close to resolving this now that those regulations were adopted. I will turn this over to Deputy Director Michael Miles to facilitate this agenda item.
Again, for the record, Michael Miles, Deputy Director of the CCB. As previously discussed, Blackbird Logistics submitted NCCR 4.145 petition requesting a change to the two-driver rule under NCCR 13.025 subsection 5 to a single driver. To date, the board has granted emergency relief due to COVID-19 and has waived the two-driver requirements for a limited time. We just amended the regulation for the two-driver rule, but unfortunately, again, it won't be approved at a minimum 2 to 3 weeks from today. So CCB staff recommends an additional extension until the potential new reg is made permanent.
And I'll just like to add, Bill, we do have a representative from Blackbird if the board has any additional questions on that. Through Zoom.
Okay. With anyone wish to make a motion?
Mr. Chairman, this is Member Nylander. I would move for an extension of the relief from that particular regulation 13.0255, and that the extension be until the effective date of the previously discussed regulation 13 as part of our overall package from today.
This is Member Merritt. I second.
It's been moved in second. Discussion. I would just note for the record, we received the supplemental information from Blackbird as to what was being put forth today. Blackbird's concerned still as to the two-driver rule. It would have been helpful if you had given us information from other jurisdictions as to what, in fact, they are doing in those jurisdictions, if anything, and what their rules are. But as we indicate, rules are a work in progress. With that, motion on the floor to continue for the limited time. All in favor, say aye.
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 Any nays? Carries for the limited extension.
Thank you, Chair. So we'll move on to agenda item number 12. This is approvals and resolutions. This is a notice of final licensure. So those licensees that have been issued their final license and become operational since the last board meeting. Chief Steve Gilbert is here to present for discussion only the single licensee that became operational. So Chief Gilbert, when you're ready.
Good morning, Chair, members of the board. Steve Gilbert, Chief of Administration for the record. Agenda item 12A is an informational item presented as a notice to the board of establishments that have been issued their final license since the last board meeting. And we have one license to note today. On December 5th, 2018, Deep Roots Harvest Incorporated was issued a conditional license for an adult use retail store in the city of Reno. On June 17th of 2021, the Cannabis Compliance Board conducted a pre-opening inspection and audit of the facility located at 12240 Old Virginia Road in Reno. The inspection and audit results revealed the facility was in compliance with NCCR and Title 56 of NRS. A statement of no deficiencies was issued on June 22nd of 2021, and as a result, the CCB approved and issued a final license to Deep Roots Harvest Incorporated on July 2nd, 2021. With that, Chair, members of the board, I'm happy to answer any questions.
Any questions? This was on for discussion, so we can move the agenda.
Great. Okay, so that brings us to agenda item number 13. This is the Cannabis Advisory Commission updates and actions. I'll go ahead and handle this item. Just an update for the board on the Advisory Commission. It is up and running. We've had our first meeting held on July 13th here in Las Vegas. At the meeting, I appointed a number of subcommittees, 4 subcommittees: Subcommittee on Public Health, Subcommittee on Public Safety, Subcommittee on Social Equity, Inclusion, and Diversity, and a subcommittee on market stability. Membership of these subcommittees include not only actual commissioners, but also members outside of the commission. We have representatives from both political parties, state legislators from both political parties. We have representatives from state and local government, as well as individuals outside of both those categories, but who represent some expertise in the cannabis industry. So we're excited to get started. Those subcommittees will begin to meet likely in the first few weeks of August. They do have some near-term tasks ahead of them on consumption lounges. So there are some pieces of consumption lounges which will likely be an NCCR number 16 when it is done, but they all have a little part to play in that in the short term. So if all goes well, we will likely see some recommendations out of these subcommittees, which will then come in front of the greater commission, which then, if approved, will come before this board to consider and approve as part of our NCCRs. I look forward to bringing these recommendations back to this board. I look forward to working through consumption lounges in the program and developing our regulations around it. So any questions on the Cannabis Advisory Commission from the board?
Looking forward to their working papers.
Okay, so I will move then on to agenda item number 14. This is the briefing to the board from the executive director. I've got 2 things. I'm going to touch on consumption lounges yet again. When we spoke the last board meeting, we indicated that the first step would be a letter to the industry, a letter to retail facilities, notifying them or indicating that they may qualify for a retail attached consumption lounge license. That is a mandate from AB 341. That letter was sent on July 9th to all licensed retail stores. It was also posted online. We also tweeted it. If you didn't get a letter, you can download your own letter on our website. This was all to ensure that everyone did receive that letter. What we included in the letter, though, was a request for a letter of intent back from any licensee that felt that they would like to apply for a retail attached consumption lounge and that they could reasonably open that lounge in the first half of 2022. This was not a requirement, but something we requested so that staff could get a head start on some of the background and suitability checks that will be required from licensees. Some of our current retail establishments have undergone background and suitability checks as a result of transfers of interest that this board has approved. Others have not. So where we can get a head start on that work, we would like to. To date, we've received around 14 letters of intent from operational retail establishments. We set a deadline, a soft deadline, well, if you're listening, a hard deadline of July 30th to receive these letters back. Again, these aren't a requirement. So as we approach that date, it looks like we have maybe around less than 20 of these letters. A lot of these will allow us to get a head start on the background and suitability checks. We did receive some letters from those retail establishments that are not operational. So, important for the record, this is not going to be the only application period for retail attached licenses. I certainly understand why they sent their letter of intent, but I just want to make it clear this isn't the only shot for those facilities that are not yet in operation. Other than that, I did mention that the subcommittees from the advisory commission will begin to work on some of the regulations. We are conceptualizing what an NCCR 16 would look like at the same time. We will have a number of public workshops on that as well. We have a web page that is live on consumption lounges. Eventually, the applications and anything surrounding the application and licensing period will live on that webpage. Right now, it's a lot of FAQs. We also have a single dedicated email address for consumption lounges that we will use to compile questions and certainly deliver those answers to the industry collectively so that everybody has the same information at the same time. So before my second item, if there's any questions from the board on consumption lounges, I'm happy to answer those.
Questions?
Okay. Lastly, a brief update on some action at the federal level. On July 14th, the Cannabis Administration and Opportunity Act, it was a discussion draft, was released by Senators Schumer, Booker, and Wyden. This is a 163-page discussion draft. It centers around the descheduling of cannabis and the administration of legal cannabis nationwide. As expected, it builds on the MORE Act that was passed, as you know, in the House. It centers around administration at the federal level from, or transfers administration from the DEA to the Treasury Department, facilitated through the TTB, which is the Alcohol and Tobacco Tax and Trade Bureau, as well as the FDA. It envisions an MOU between those two federal agencies, similar to that of alcohol and tobacco. It touches on, obviously, the administration and licensing of cannabis. It touches on federal excise tax, restorative justice programs, and expungement issues, and then, an emphasis on research opportunities as well. We're still going through the document. There's certainly a deference to states and state structures included in here. States similar to alcohol will be able to elect not to have cannabis as part of their state commerce. However, they can't prevent, in the event of interstate commerce, cannabis going through their state. There's a lot of holes in this discussion draft. They're asking for a lot of feedback from stakeholders. And so important things like interstate commerce or testing standards or product standards is still left to the feedback that they receive and obviously future iterations of the legislation. So just kind of a brief update. I will provide more updates as this thing gets legs. As you know, our national organization of regulators, CANRA, we will likely engage at some point. I believe they're asking for feedback by September 30th, and I will certainly keep the board apprised on any kind of feedback that that organization may put together. So with that, happy to answer any questions on the opportunity or the Administration and Opportunity Act. All right. So that concludes my report. Looks like we're on agenda item number 15, the next meeting date. Chair, I'll turn it back to you.
That is proposed for the 24th of August. That then takes us to items for future agendas. If any board member has any today, please so state. If not, get them to Director Clemens and he will take care of that. I will say, just for public comment, the board does appreciate the cooperation of all the licensees as to our pandemic situation here in Nevada to keep us up and going. And your work has been outstanding this far. So our public comment.
Great. We'll move on to the last public comment period. If there's anybody here in Las Vegas who wishes to provide some public comment, please come on up. Seeing none, Chair, and if any comment came in through the email during the meeting, we will certainly post that online as well. I will give it back to you, Chair, for adjournment.
Do we have a motion for adjournment?
Motion to adjourn?
We're adjourned. Thank you.